Good day. My name is Laura King, and this is my colleague, Louise McAllister. We live in Corvallis, Oregon, and we are looking forward to sharing with you our research and work on a study around the Supreme Court. And that's the topic of this presentation. And go ahead and start sharing our work. Right. As I mentioned, our topic is the Supreme Court, and we're looking at this from the past, present, and future. And today is December 5th at the time of this recording. Before we get started, I just wanted to say that throughout our presentation, we have some trivia questions just to keep you engaged. Should you want to play along, go ahead and pause your video when you see those questions so you have a moment to ponder your answers. And then when you resume your video, the next slide will reveal the answers and we'll continue our talk. So we hope you enjoy the questions as well as the content of our work. First, I want to begin with our bios. Louise, do you want to go first?
Sure. My name is Louise McAllister. It is my great privilege to be Laura's mom. I was born in Missouri and grew up in St. Louis, where I attended St. Louis University, graduated in 1957 with a degree in English, which was a popular major for girls in those days. Later on, in the summer of 1977, I was awarded my JD from the University of Puget Sound School of Law, which later became the Seattle University School of Law. I was admitted to the Washington State Bar in 1978, and I practiced family law as a sole practitioner in the Seattle area for about 15 years. I am now a retired attorney, and I put that in quotation marks. Is something most lawyers are reluctant to say, but it is a fact that I am retired and it's fine. Okay.
Great. So the truth is revealed. This is my mother. Thank you, Louise. My background is not, I'm not a lawyer. So true transparency. However, I do have a doctorate in material science and engineering. And that has given me a great expanse of learning how to look at facts and data and do analysis, do research, thorough research, critically think about the material, apply statistical methods if appropriate, engineering methodologies, etc., experimental methods, hypothesis testing, etc. And it is with that skill set, I like to apply that not only in my career and work in high tech and in sciences, but also in an area that's quite of interest to me, which is civics, governance, and citizen engagement. And so it was with those skill sets that I've learned over the last 35 years and applied over the last 35 years in my career. I'm applying that now to this topic. I am recently retired, and I am excited to be able to spend some of my retirement time developing further my interest in the topic of civics and citizen engagement. I've recently given a number of talks on the history of voting, for example, importance of voting in the primaries, and now this topic, the Supreme Court. I have 2 grown children and I have 2 grandchildren. And I think I just want to add that I reflect on why did I get so interested in science and analysis and study and just love learning. And I have a curiosity and a wonder. And I have to say I credit that to my mother. We would sit at the kitchen table while she's studying her torts, etc., side by side. I'm looking at my math and sciences when I was in my junior years of school. And I think that's where it all began. Our motivation for this talk is, well, in June of this year, as the Supreme Court always does, they roll out their decisions that they have been working through in the prior months of their term. And this particular year, there was a number of decisions that came out that were disruptive one of which was the overturning of Roe v. Wade and Casey, which had been understood to be settled law for the last 50 years. This stunned millions of Americans and yet relieved many others. Our reactions in our society span from disbelief, anger, betrayal, fear, confusion, to celebration, relief, maybe even some righteousness. Today, our nation, as we know, is deeply divided and politically polarized, so our emotions can be on high alert at times. This was one of those moments. And consequently, we have a challenge before us, which is to how do we look at things objectively as a society? How do we have meaningful dialogue with someone of a different point of view? And it's so important to realize that our democracy requires objectivity, critical thinking, constructive dialogue, and engagement. And our society will be best when we can connect with another with a diversity of thought and respect the other and learn. So our goals for this talk is not only to understand the Dobbs decision from an objective mindset. I just want to, full disclosure, we're not going to debate Dobbs here today. We want to lead with curiosity and a desire to understand the facts behind this decision. We want to gain perspective about this current Supreme Court from our history and view and examine them with that context. And then we want to conclude with how we as citizens fit in and contribute to this landscape. Here's our first trivia question. So please pause and go ahead and take a shot at these questions. And now here are the answers. Roe v. Wade was decided in 1973. And what is stare decisis? This question was a little tricky. Stand by things decided is the correct answer, but the other ones can also be argued and applied. Dobbs v. Jackson Women's Health. This was the essence of the decision. As we know, this was not a unanimous decision. The court decided this 6-3. And the essence of the decision reads, we therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be overturned to the people and their elected representatives. This was written by Justice Alito, who is writing for the majority. I think it's important to note, just in this statement alone, that it points out the fact that there's never been any action by Congress in the last 50 years to codify Roe v. Wade. And he brings this to light. Additionally, this decision, just to note, was 166 pages, right, Mom? Louise? And you can find it on scotus.org or the supremecourt.org, full pages. But we plucked out some of the key things that we thought were relevant for this discussion today. The Dobbs decision continues. There's a risk that an American people will perceive a decision made for unprincipled reasons when the court overrules a controversial watershed decision such as Roe. But we cannot allow our decision to be affected by extraneous influences such as the concern about public's reaction to our work. The court has no authority to hold on to an erroneous precedent as permanently exempt from evaluation. Stare decisis adherence to precedent is the norm, but not an exorbitant command. Nothing the court does today casts doubt on precedents that do not concern abortion. Rights regarding contraception and same-sex relationships are inherently different from the right to abortion because the latter uniquely involves what Roe and Casey termed, quote, potential life, unquote. I think a couple things that I highlighted here is the blue text is really, reads as he is addressing the fact, and we remember this decision was leaked and is leading with, we're not going to be influenced by a public's reaction. That's not the duty of the court is to be objective. And then he also puts in strength around recognizing that there is precedent, and we understand those to be not be changed very often, but the conservative part of this court is seeing this as an erroneous precedent, and so feeling driven to change it. And in the dissent, of course, there's always a dissent when we don't have a unanimous decision. Breyer, Kagan, and Sotomayor wrote expanded quite a bit on this. So if you're interested, please take a look at that. But this one was jointly written. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception. In turn, those rights led, more recently, to rights of same-sex intimacy and marriage. Either the mass of the majority's opinion is hypocrisy or additional constitutional rights are under threat. It is one or the other. So this is a very strong criticism of the majority. You can see that the differences, you start to see some of the difference between the conservative thinking and the more progressive or liberal thinking. How they look at the law is very different, and it's quite interesting to see that they can come away with very different conclusions. So let's move ahead with our presentation. The past, present, and future, like I said, would be our focus. And Louise is going to kick us off with the past. And before we have to do that, we've got another question set for you all. Go ahead and take a look at this. Pause your video. And here are the answers. All right, past, go ahead, Louise. History of the Supreme Court provides context and informs us of the present.
The US Constitution was ratified, actually deemed ratified on June 21, 1788, after 9, that is 3/5 of the state had voted to ratify. The ratification process was contentious and took almost 3 years to get all the states on board. Meanwhile, Article 3 created the judicial power in the United States, vested in one Supreme Court and inferior courts as Congress may establish. It goes on to say the judges, both of the Supreme Court and the inferior courts, shall hold their offices during good behavior. That simple language establishes the beginning of the judges. There is no mention of length of term. It is simply during good behavior. Article 3 goes on to lay out the scope of jurisdiction of the court. It is interesting that there is no articulation about the power of the court to carry on judicial review. So Congress then passed the Judiciary Act of 1789, which establishes the court itself. The court then assembled on February 1, 1790, in the nation's capital, which was then New York City. The articulation of judicial review occurs in the landmark decision in 1803, known to all law school students as Marbury versus Madison. This was accomplished and defined by Chief Justice John Marshall when the opinion of Marbury versus Madison found that a section of the Judiciary Act of 1789 was unconstitutional. That has been the purview of the court ever since. The structure of the court is as it was established in 1789. one court with 6 justices. Today, there's still only one Supreme Court with 8 associate justices and 1 chief justice. The Federal Circuit appellate courts began with 3 circuit courts, north, middle, and southern areas of the country. Today, we have 13 circuits across the country. Our federal district courts were established with 1 in each of the 13 states. Today, we have 94 across the 50 states. So what does the court do? The action of the court begins with a grant of certiorari, that wonderful Latin word meaning to be informed. The court will entertain petitions. Actually, they receive many thousands, perhaps 8,000 a term. They grant only about 85 to 90 of these petitions. The petition will ask for a review of the record from a lower court, or it will bring in front of the court, ask the court to address an urgent issue. If upon the grant of certiorari, the court will schedule oral argument, will consider in due time across its term, the length of the term, argue the case among themselves, write an opinion, make a ruling, which then will be issued at the end of their term, usually in mid to late June. Another function of the court is the shadow docket, which was originated to decide emergency requests or decide procedural matters. It has presently is under some criticism for being used to quickly address an issue without even listening to argument. For example, in recent weeks, in the shadow docket, the court reinstated Alabama's gerrymandered congressional map after several lower courts had ruled that map discriminated against Black voters. But the court stepped in on shadow docket, made a ruling, allowed the gerrymandered map to stand and function during the 2022 midterms. So there is current criticism of the use of the shadow docket as premature and non-transparent, but it goes on. How is a Supreme Court justice selected? Well, the president is given several candidates to consider. It is the president's duty to nominate a candidate. The nomination is then sent to the Senate Judiciary Committee. The committee holds a hearing with the nominee present. They listen to witnesses both supporting and opposing the nomination. Some of us may remember the committee hearing at the nomination of Justice Clarence Thomas, which turned out to be quite a contentious event. The senators will question the nominee and listen to his or her qualifications, his or her philosophy, and his or her opinion of precedent, which we recall now is played up in the nomination processes of Justice Kavanaugh and Justice Amy Coney Barrett. The committee will vote on the nomination and send the recommendation to the full Senate. The full Senate will debate. At the present time, a simple majority is required for the confirmation of a nominee. The Senate rules formerly allowed unlimited debate, which could only be ended by 60 senators voting, known as the cloture vote. This practice was ended by Mitch McConnell, leader of the Senate, at the encouragement of then President Trump upon the nomination of Justice Gorsuch in April of 2017. This lowers the number of votes required to confirm a Supreme Court nomination to only 51. And that's the way it stands at the present time.
Thanks, Louise. And just as a reminder, in our Constitution, we have the Articles 1, 2, and 3, which establish Congress, the executive branch, and the court. There's always been a check and balances spoken throughout the Constitution about how these three entities can stay equal in a sense. Article, as Louise mentioned earlier, the Judiciary Act is an example of Congress passing legislation to scope the court, for example. The selection process of justices is a perfect example of using the president who nominates and then the Congress who then approves. With regards to judiciary acts, when I first heard this term, I wasn't familiar with how often they have been used in our history. Currently, we have a number of judiciary acts in Congress, the current session of Congress, both in the Senate and the House. You're encouraged to look those up. They are about addressing the court's balance, in a sense, the idea of lifetime appointments. As Louise mentioned, 51 votes puts in place a justice for life. And one could argue or be concerned about that, as a simple majority maybe is too low a threshold for an appointment like that. So the first Judiciary Act was 1789, as Louise described, which really got the court in motion. There's been a whole history of these, as shown here. We're not going to dive into these. I do want to mention sometimes these acts are done to rein in the court, if it's overreaching, in addition to just clarifying things for the court. One example of a time when the court was overreaching was the Lochner era. This was a period of the late 1800s and into the 1920s, almost 1930s. If you recall, this is a period of industrial revolution. Lots of new work was unfolding. Industry was requiring workers. And at the time, the concern for the health of the worker started to emerge. For example, limiting the workday or limiting the number of days in a work week, safety protections, etc. There were the states started passing laws to protect the worker. And during this time period, the Supreme Court overruled over 200 of those state rules in favor of the industry. As FDR became our president at the time, he had this New Deal agenda, and he saw that this court was going to be an obstacle for his agenda, and he was moved to discipline the court in a sense. He threatened to expand the court. He threatened to implement life terms. He made motions to do that. In the end, Congress was a check on him. They did not enact those, but the act of and the movement of the president to do that did impact the court, and they pulled back on their activism in a sense, and started to line up in support of the New Deal agenda, in the sense that they weren't going to be overturning it along the way. Louise mentioned Marbury versus Madison as the first landmark decision. There have been a number of landmark decisions, and I'm going to segue into that right now. These decisions can often reflect the court, the character of the court, etc. And while Marbury versus Madison still stands today, giving the court the power to overturn, see through the lens of is this law constitutional or not, and then act on that. There are other decisions that the court has made that haven't stood the test of time, and actually have been in part because they've been terrible decisions. it's important to remember that at the end of the day, these are just people that populate the Supreme Court. They're educated, they're smart, but they're still capable of making poor decisions. So if you look at this chart, we got 1789 in the top left, and it just meanders, serpentines down to the current day. I've highlighted 3 terrible decisions early on in our history. Dred Scott v. Sandford was the decision that was made that stated that even a free slave will never have the rights of a full citizen in the US. That obviously was overturned in a sense by the Civil War that occurred shortly after that, and the 13th, 14th, and 15th Amendments. A number of decades later, though, Plessy v. Ferguson was upheld, and this started the practice of the Jim Crow era. Separate but equal is constitutional, is how the court ruled then. And that wouldn't be overturned for some time. The Lochner era I mentioned earlier, Buck v. Bell, go ahead and take a look at it. I'm not going to expound on that, but that's another egregious decision by courts at the time. Where I want to focus for the rest of this past view is the last 5 decades of courts. The Warren Court, Berger Court, and Rehnquist Court, leading up to the current court, which is the Roberts Court. Trivia questions. Go ahead and pause. Take a stab at the answers. Here are the answers. The president, FDR, was accused of packing the court. He wasn't successful in that endeavor, so the answer is none. Under which presidents were there 10 justices? President Lincoln. The court that was considered to be the most liberal in US history was the Warren Court. The court which struck down the most laws that were expanding federal powers at the time is the Rehnquist Court. And the decision that was made that resulted in racially integrated schools in the end of the Jim Crow era, that basically the overturning of Plessy v. Ferguson, was the Brown v. Board of Education. Backey v. UCB is a ruling on affirmative action. Warren Court existed between 1953 and 1969. This is a time of a lot of cultural upheaval, as folks will remember. Brown v. Board of Education was a key decision by this court. They had a number of decisions that were instrumental in establishing one person, one vote and setting congressional districts by population in the states. There was the first contraception for women's health ruling in support of contraception. The Miranda Law was also ruled on, and Loving v. Virginia for interracial marriage. The Berger Court followed in 1969 to 1986, also a fairly stable court, a long period of decisions. This one was an interesting time where we had President Nixon and the Watergate. We had the end of the Vietnam War. This court ruled that the Pentagon Papers needed to be shared with the public. And it also ruled that Nixon, this was a unanimous ruling, US v. Nixon, where Nixon had to reveal the Watergate tapes. This was the court that also decided Roe v. Wade, UCB versus Bakke, which is affirmative action. And we start to see some of the first environmental laws being supported with the EPA and ruling to protect the environment by this court. And then the Rehnquist Court, 1986 to 2005, also a fairly long period. Again, another ruling for women's health, Planned Parenthood versus Casey. We start to see some gun legislation in favor of the Second Amendment, allowing guns on school grounds. There was also the contentious election board, Bush v. Gore, that this particular court weighed in on. And then we see another ruling on affirmative action, in support of affirmative action. So these are the courts that preceded the current court. The Warren Court has been considered to be the most activist court in our history, and we call that judicial activism. And the Berger and Rehnquist courts were more centrist and often aligned with societal trends. And I think it's interesting, as we were looking at this, it's really interesting to think of the time periods that a court is existing in and what that backdrop is, societal trends and executive policies at the time, and how do those influence a court, or do they? So we're going to step into the present court and look at that in the context of this past and this history. Again, we got another trivia questions for you. So go ahead and take a look at the questions and see what answers you come up with. Pause your video. And here are the answers. What is the name of the current Chief Justice? That would be Justice John Roberts. What is the current Supreme Court Justice that has never served as a judge? That would be Justice Kagan. And we actually have one justice who served as a corporate lawyer, and that's Justice Thomas. And the decision to allow for unlimited contributions by corporations to political campaigns was the Citizens United versus FEC. The court ruled on both of these cases, actually, but this was the answer to that one. Shelby v. Holder was the decision to basically revisit, gut, in a sense, the Voting Rights Act by declaring that the formula that they use, that is used today, is no longer accurate and needs to be updated. That was a very contentious decision as well. How many Supreme Court appointments did President Obama make? He made 2. He had an option for 3, but that was, as we know, that was blocked by the Senate at the time. And President Trump did make 3 appointments during his tenure. So the Roberts Court, who, by whom? When will they be 80 years? I think that's an interesting one to think about. So first of all, there's their names. And Chief Justice Roberts is the center one right here. And I've listed the names of the presidents that nominated them. And there's been a criticism that when we have our elections, we have a president wins the popular vote and the electoral vote, or just the electoral vote. There's only 4 times in our history where the president has not won both the electoral and the popular vote. That would be President Trump, for example, and George W. Bush's first term, but not his second term. So I'm only highlighting in yellow the influence of that election outcome on a president's weighing in on the Supreme Court. But these 2 nominees were nominated by Bush in his second term. Their ages, we have quite a young court, and in the sense, and that's concerning because these are lifetime appointments, even though the Constitution doesn't state that that's required. But today they are lifetime appointments. So Amy Coney Barrett will be 80 in the year 2052. Justice Kagan will be 80 in 2040. Justice Jackson will be 80 in 2050. So this court is in place for a while. What about their backgrounds? I found this very interesting. We created this table to just kind of look at a number of aspects of them. But education, their career, whether they had a role at all in the executive branch, which I found in this work to be a little bit disturbing, that someone who's working as in the court actually had a stint, maybe a fairly number of years in the executive branch. And how does one, not come away with being a little bit political? And then, of course, their judicial philosophy, which gets a lot of airtime more and more these days. So only one of our justices did not go to an Ivy League law school. That would be Justice Barrett, Amy Coney Barrett. I think it's also interesting that not every justice served for a Supreme Court justice. So they may have clerked, but they didn't necessarily clerk for a Supreme Court justice. Thomas, Justice Thomas is the only one who worked as a corporate lawyer. That was for Monsanto. We have 3 academics in the bunch: Justice Gorsuch, Justice Kagan, and Justice Barrett. Barrett and Gorsuch wrote a fair amount of reviews in their tenure as professors. Kagan was a dean and really focused on the students and the quality of the education, the balance of the school, even reaching out to get a conservative professors into the staff so that the school was more balanced. There's only one justice that's been public defender that came up on the hearings of Judge Jackson. And a number of the justices have served quite a while in courts as a district judge, as well as a Court of Appeals judge. That would be Sotomayor and Jackson. 5 of our justices have absolutely, 9+ years on the federal bench, so quite extensive experience. But we do have a judge, Judge Kagan, who never served as a judge until she became a member of the Supreme Court. And the executive branch, there's a couple justices that didn't have a tour of duty, so to speak, with a president, but a number have had either were Solicitor General, counsel to the president, maybe served in the Department of Justice. So again, I found that kind of interesting. And I did look in the past, this wasn't unusual. Justices way back were connected to the president, even socially. So I think it's really hard to separate and expect that, in at least historically, it's shown not to be the case as well. Oh, I wanted to say one more thing. The originalists, we have got 5 declared originalists. This is the viewing the Constitution through the lens of our founders. And then there's the judicial pragmatist approach, which is viewing the Constitution as something that evolves with our knowledge, our social experience, etc., and the need to adapt. And then both the Chief Justice Roberts and Justice Jackson, the newest member of the court, are a combination of that. They don't declare themselves one way or the other. I think this is an important thing to think about as we look at this particular court. I think another thing I found interesting was the religious faith affiliation. There's all but 2 are Catholics or Anglican Catholic. Jackson is Protestant and Kagan is Jewish. And how does this compare? I was curious how this compared to our demographics in faith as a country. What we see on the left is what the court is comprised of today. And on the right, we see what our demographics are in our country. The Protestant is the #1 faith affiliation. And the second most is unaffiliated, which doesn't mean atheists, it's but not assigning themselves to a particular faith. And it's not represented at all in the court today. Catholic is 3rd, and then Jewish is 4th. So we really have a court that doesn't reflect our population.
Laura?
Yes.
I read recently that a 2021 study, by whom I'm not sure, found that religious interests had 81% success rate in the current Supreme Court whenever the case represents some kind of religious, quote unquote, religious interest.
Right. Yeah. Thanks, Louise, for that. And that's actually coming up in the news right now in terms of a concern around that some of the influence of maybe wealthy religious people even in neighboring with and having meals with some of the justices on this court.
Yeah.
So more stay tuned for that. But and I think given that statistic, Louise, it might be interesting for us to take a look at, well, does that hold water, 50 years ago? We don't know. We don't have an answer for that for our audience today. But yes, thanks for that, Louise. So here is what I showed earlier about the history, the previous three courts that were, basically in play for the last 50 years. I want to compare the Roberts Court to that, or put the Roberts Court in context of that. So Roberts Court began in 2005, so it's been happening. And here are some of the decisions that have been made already by this court. So what you can see, there's a number of gun rulings. These are tending to uphold the Second Amendment rather than the concerns brought to the court on the larger, influence of gun safety from other people's points of view. This court ruled on Citizens United, which was open the floodgates of money in our politics. We've all been exhausted by that, I think. This also was the court that decided on Obamacare. It was basically, the court decided that the individual mandate would be upheld, but the court did decide that the federal government, the executive branch, could not force the states to expand Medicaid. So there was sort of a partial win for President Obama and a partial win for the states that were resisting the ACA. Shelby v. Holder, this was basically I mentioned it earlier, really took the meat out of the Voting Rights Act of 1965. And there's been legislation since to try to restore that, the John Lewis Voting Rights Act, but that did not pass by Congress this last January. There's Obergefell versus Hodges for same-sex marriage. There's no more legislation in support of, on the topic of voting, gerrymandering issues that are coming before the courts, and looking to the courts to help rule and sort that out, all the way to Dobbs v. Jackson, women health. We also had another disruptive decision that came out of the court this June, was the West Virginia v. EPA, which was basically pulling back on the obligation of oil and gas to move quickly to green energy. They could still monitor carbon concerns from traditional technology, but they basically bound that. And then we had the Kennedy v. Bremerton, which was around act of prayer in a public school setting. And what's pending? What's coming before this court? What are we anticipating this year? There's a couple cases around voting. Louise is going to describe one of these in particular in a minute here. We have another case pending around the affirmative action. We have another case around environmental protections, and this being clean water and private ownership. And then we have an interesting one, Halen v. Bracken, which pertains to adoption of Native American children. So I think the question, when Louise and I were looking at this has been a very active court. And in the past, in the context of the past three courts and our current social norms, has the Roberts Court made equally, if not more, disruptive rulings in the past 15 years? Remembering that Warren court was criticized for being a very activist court, very disruptive liberal decisions, and Rehnquist being criticized for pulling back on some of the federal protections for environment, for example. Is the character of this court one of judicial activism rather than judicial restraint? The latter being something that a conservative position is, that you want a court that's judicially restrained. So here's a little bit more about these courts, these cases that are before the court this year. Louise, you want to go ahead and
yes, we've
stand on a couple.
We picked out Moore v. Harper to describe in a little more detail. This case comes out of North Carolina. Actually, it was an appeal from the North Carolina, their own state legislature, where they had created an extremely gerrymandered congressional district map, and the voters resisted it, and the North Carolina Supreme Court tried to overrule it. The legislature responded by appealing directly to the United States Supreme Court on the grounds of an argument which they have called the independent state legislature theory. Critics say that this is a very unfortunate misinterpretation of the Constitution. This theory has been debunked by 48 Friends of the Court briefs, which have been filed in this case. A very large statement from Supreme Court justices in the various states have gathered to make a case before the court in this Moore v. Harper that this would be a dangerous thing to do. Actually, it would the effect would be that the state legislature would have the final unreviewable authority to count the votes in a federal election. This would actually throw a federal election into chaos. It could be replicated in many other states, creating chaos all over the country at the time of a federal election. This has been criticized by many court commentators, and also criticized even by the military as a possible occasion for national security to be endangered. It's interesting that 4 justices agreed to hear this case. We don't know which 4 they were, but they took it on knowing what the question was going to be. So we'll find out in June how they feel. It's interesting to note, though, that there is in the congressional pipeline a piece of legislation called the Electoral Count Reform Act, which would clarify the procedure, which squeaked through the Senate on January 6th, in spite of the chaos that was going on in the Capitol. So it would be interesting and probably benefit to promote the passage of this Electoral Count Reform Act if the current Congress could get it done before January 1. The second case we're looking closely at is fair admissions versus Harvard, or students for fair admissions versus the University of North Carolina. These two institutions of higher learning were criticized because their admissions policies include a look at the individual's race. It was supposedly brought on behalf of white and Asian students. And I say supposedly really in quotation marks, because it is known that the case was instigated by an individual whose name is Edward Bloom. This man makes it his practice to find issues that he deems worthy of asking the Supreme Court to overturn. So he goes looking for plaintiffs in order to create a case to make new law. So just a little background on that case. It was in the news a week or 10 days ago when the argument was heard. It may make a big change in the way students are admitted to universities. So the others, I would say the bottom one here, the 303 Creative versus Elenis was in the news just today or yesterday. This is actually one of those cases involving religious beliefs. The creator of a website contends that she cannot be required by Colorado law to create a website for a gay marriage because it interferes with her personal religious belief. we'll see where that one goes.
All right, thanks, Louise. So I think it's also interesting, as Louise mentioned earlier, there's the court grants cert. They have many requests, 8,000+ is what we've read and understood. So what they pick and how they rule is illuminating about the court, and it should inform us about their character and their judicial approach. So I think this applies to the Roberts Court as well. So influential forces, as noted in the majority opinion by Justice Alito, he reminds us that the decision by the court is not going to be affected by the public's extraneous influences, such as public's reaction, fear of public reaction to our work. But what about other influential forces? Is the court insulated so much that it cannot be influenced? And we looked into this, and we wanted to talk about 3 different aspects that seem to be potentially of concern from a citizen's point of view and how they influence our court: the Powell Memo, Federalist Society, and dark money. So the Powell Memo, this was interesting to discover. This was written by Lewis Powell, who later became a Supreme Court justice, actually just months after this memo was distributed. It was a memo to the US Chamber of Commerce, and it was basically sending off the alarms for, in defense of businesses. At that time in the 70s, laws were being passed to protect the environment, for example, and companies were starting to feel that constraint. So they felt they were caught flat-footed. It was a call to action for businesses to engage basically in the political process. We know what that looks like today, but back then, even the first 10 years after the memo, we see an explosion of public affair offices growing in DC, 100 to 500 in just 10 years. We see an increase in registered lobbyists from 175 to 2,500. These are lobbyists representing business interests. And then we see the beginning of an explosion of corporate PACs, and we know how that is today. We pulled out this memo, we looked at it. It was a scathing rebuke on basically legislation and courts, and how this was going to really ruin the enterprise, free capitalist society we have. And this is a photo up here of Nixon, President Nixon, who did nominate Justice Lewis Powell to the court not long after this memo. So I think it's interesting. There's still references to the Powell memo today. So I'm curious, Louise is curious, did this message and strategy predisposition judges at the time to empathize with business over worker, over the climate, over the environment? Did we begin to see this effect with the Rehnquist court, which was the court that started to overturn some of federal powers that were constraining businesses? So how is this memo continued? Well, potentially one way it's continued is through the Federalist Society, which was formed in 1982 as a club, in a sense, at a law school. I have empathy for why this was formed. At the time, it was noted in our reading that there was a lot of progressive lawyers, professors, etc. And if you were of a conservative mindset, you were often isolated in the classroom. You might even been teased or taunted. So it was definitely not friendly grounds for a student in law school at the time who had more of a conservative mindset. And so this Federal Society was formed 40 years ago. They were concerned with the threat of liberal ideology. They saw it as a real threat, and they really wanted to make sure that there was a counterbalance to that. They claim that the purpose is to sponsor fair and serious and open debate, which is something I think we all would like, They have a significant budget, $20 million a year, 90% is from individuals and foundations, such as the Koch brothers is a big contributor to this organization, for example. I spent some time on their website, getting all geeked out, listening to some of the talks. I got to hear Justice Amy Coney Barrett, give a presentation, for example. Same thing for Justice Gorsuch. I also looked for some of the liberal, progressive participation in their panelists and in their talks. The society is interesting. It has, as a disclaimer, almost this statement up here in the top right: the Federal Society takes no position on particular legal or public policy issues. All are expressions of opinions, blah blah blah. And it did presents its purpose as trying to create this level playing field for open thought. But as I listened to the talks, I feel that they were disingenuous in that. I encourage you to go to their website and look and judge for yourself. There would be often, there's the token progressive or liberal view, but they are in isolation. They even lead with, well, I guess hopefully I won't be fed to the wolves today, or some lines like that. They're very clearly alone in their presentation, and they'll talk about a concept such as precedent and debate it. But in the end, it's definitely an audience and a panel that is of more of a conservative mindset. So I feel like they're disingenuous in that. Memberships include election deniers that have been in the news of late: John Eastman, Senator Cruz, Senator Hawley. And the last thing I'll say is this: their co-chair and former executive vice president is Leonard Leo. He's been a longtime member and leader of the Federalist Society. And he's a conservative, he's a conservative Catholic, and he's very influential in conservative policy and thinking and in politics. What about the court? Who is associated with this society? Well, we actually have 6 justices who are members of the Federalist Society, or at least a former member. Chief Justice Roberts likes to point out that he was a former member, not a current member. There's some criticism of this influence of the Federal Society. You can see the comments here by Senator Dick Durbin, who's on the Senate Judiciary Committee, that is the committee that reviews nominations for the court, and noting that the Federal Society is very proud of the fact that it has influenced Republican presidents on every appointment to the Supreme Court in recent years. Going back to President Bush, G.W. Bush, he had nominated, you might remember, he nominated Harriet Miers. I remember being excited about a female nomination, potentially conservative, yes, but you remember she withdrew her name. And as we read more, this was because of the Federal Society influence. They really lobbied to President Bush to put forth Samuel Alito's name and to pull her name, and that's what happened in the end. Additionally, the Federalist Society helped identify 43 of 51 of President Trump's lower court nominees. So they definitely have a influence on current court and conservative thinking. And it is just one entity. There are other societies. There are progressive societies that counter this. They're not as necessarily well funded as this one. But I was looking for, is there another conservative society, school of thought for lawyers and justices? And there really isn't. So to me, the concern I have about the Federal Society, it's a narrow representation of justices, of conservative justices in a sense, or conservative lawyers, conservative thought. And are we just getting to the point where we're getting cookie cutter of a conservative type of justice? We would like to have more diversity in our court, and certainly diversity includes within even the conservative mindset. The other external influence is dark money, and this, of course, came about by the Roberts Court's decision to allow for Citizens United to rule on Citizens United. This is what opened the floodgates of money, dark money, meaning that money that goes into influencing our politics, and there's no traceability about who's behind that money. So it's not transparent at all. You can see here on the right, Citizens United was ruled in 2010, and you can see the explosion of growth in money and politics, and both parties are benefiting from that. And most recently disturbing, though, is Leonard Leo, again, the associate with the Federalist Society. He recently received the largest ever single donation, $1.6 billion from Barsed, who's was successful in his tech business. This is intended for Marble Freedom Trust, which is something that Leonard Leo founded, with the mission of, and as stated here, maintain and expand human freedom consistent with the values and ideals set forth in the Declaration of Independence and the Constitution of the United States. So this is a lot of money for one guy to do with as he please, and that's what is understood. And so there's definitely a concern about dark money in our politics, and it seems to me it's fair to say it's a concern about how it influences our court. So we'll segue to the future and how the court may evolve, and what is our role in all of this. So we just take a step back. What are concerns that Americans have? Well, of late, we have a lot of concerns about the stability of our democracy, a lot of focus on voting rights, counting of votes, election integrity, money in politics, access to voting. We also have a growing concern about climate change and the threat that that poses for our homes, our livelihoods, and access to clean water, clean air, industry and corporate versus its impact on land, communities, workers, and other social issues, of course, abortion, women's healthcare, marriage, reconciling criminal justice, and privacy. And the Roberts Court is likely to be the court for the next 2 decades. How will this court, now majority conservative court of increasingly one mindset, field these concerns? Whose right will be asserted and protected, and whom are they serving? I think these are fair questions to ask right now. The citizen's situation. The Supreme Court is the final arbiter. In its history, it has made good and terrible decisions, as we've noted, which affect our lives. Only Congress can readdress laws that are overturned, and yet our current Congress is unable to act. They're fairly impotent because of the deep divides in our politics. There are powerful and well-funded forces at play, and it's foolish for us to believe that the Roberts Court is above being influenced. And in the context of recent history and these forces, is it possible that the Roberts Court is exercising judicial activism in support of a hidden agenda, and thus will fail to meet the moment on the key issues of concern to the American people? I think it's a fair question to ask. I'm curious about what, these things. And if so, what can be done about it? So what could be done about it to manage? And this kind of goes back to the idea of if the court is overreaching, what can be done about it? What can the 2 other branches do about it? So there are some things in play. There is the ending of life tenure. And as Louise noted, there isn't anything in the Constitution that says that this should be a lifetime appointment. It's appointment of good behavior. Encourage you to look at this particular bill in the House. It's an idea of 18-year terms where every 2 years you add a new justice and rotate that one out into the other lower federal courts. So you're still honoring that lifetime appointment because all federal courts are lifetime appointments, but they're not just sitting in the Supreme Court for life. And it's a go forward. There's the expansion of the court, 9 to 13. This has gotten a lot of criticism. Oh, this is the packing of the court that FDR did, which he didn't do, but yes, he did threaten to do that. But this is an effort to get more balanced court, and also recognize that our court is, we have had 9 justices since the beginning, and yet our country has grown from 30 million to 330 million people. And as we noted, there's 8,000 cases that they only whittle down, and they only hear 80 to 90 cases. A lot of work, but they do more if they had more justices. Requiring enacting a code of ethics. I think this is the most likely to get support right now in a divided Congress. Currently, the court has no code of ethics. It's the only court in the land that doesn't have a code of ethics. And so there isn't any tool to hold itself accountable to say dinners with and outside influences, to say stock holdings that they have. So it's important. This is really probably the first step that we could all encourage our elected officials to put into place. And again, this is something that Congress can do. And then there's some other ones, as I read down here, 7 justice majority to invalidate a statute, increasing transparency. This was something that they started to do with COVID, and it would be good. It's the only branch in government where we really do, it's very opaque. We don't get to know what's going on so much. I remember I had the opportunity to go to the court and sit and listen to oral arguments, and I had to stay in line. I had to fly to DC. I had to get in line really early in the morning. I had to hope to get in the case I wanted to hear, but I didn't. So I got into a different case. I got to sit there for 10 minutes. Fortunately, I got to hear a couple of the justices ask questions, which was really cool. I got to hear Justice Gorsuch ask a question and Justice Breyer, but then I had to be scooted out. So that's not that's a privilege to be able to be there and to see that in action. So how does the citizen respond to this, given this landscape? I think it's important to learn, just keep your learning, be curious. And you're here listening to this presentation today, so yay you. I think a really important one for all of us to get behind is support the overturning of Citizens United, or at least weakening it through legislation. In the meantime, I think it's important to demand legislation to get money out of politics, particularly dark money. Demand that transparency. Right now, we have money coming into our politics. Some of it's foreign money. We have no idea. Both the Freedom to Vote Act, or the Freedom to Vote Act of 2021, that was also put before a vote and not supported in January, like the John Lewis Act, would have created that transparency. Get engaged and informed about legislation pertaining to the judiciary. We just listed some acts that are in Congress right now. Implement a code of conduct, increase the transparency, and these judiciary acts that are as noted. And then I think it's also important to establish, if you don't already have communication to your senator and your representatives, write to them regularly, call them. I have their phone numbers in my Rolodex. So here's the number to the switchboard, and you can call you can find your state, reach out to your state's senators and your representative this way. And of course, vote. I guess the only last thing I'll just say is this, we learned that there's been conservative and liberal courts in our history. That's just the way. There has been influence by relationships with presidents, etc. I think what's concerning right now, as Louise and I looked at all this, is the new influence that we have that we didn't have, that I don't see it in our historical look, is the influence of money and the influence of one particular type of conservative groupthink. And that's dangerous. And so I think that's important for us as citizens to really dive into and say, we're concerned about this, and to let our leaders, our elected leaders know that. Alexander Hamilton, closing remarks. Oh, I love Alexander Hamilton. He and Madison wrote the Federalist Papers that basically informed our Constitution. He writes in the paper number 78, the executive not only dispenses the honors, but holds the sword of the community. The legislative not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the others, and that all possible care is requisite to enable it to defend itself against their attacks. This being Alexander Hamilton, Federalist Papers. So our final remarks. So how would today's court be viewed by Alexander Hamilton? Despite intent to insulate the court from political pressures, history shows that politics is an aspect of judicial selection. Historical examples shared today illustrate that conservatives and liberals have waxed and waned within the makeup of the court since its inception. But it is a fact that the current makeup of the court is predominantly conservatives and of one type, groomed by the Federalist Society, that has been funded by deep pockets, possibly even dark money, to push one narrow ideology and potentially one agenda. Citizens must engage on this issue and work towards restoring balance of power and ideologies to safeguard our democracy. Our goals, as we stated earlier, love your feedback if you take the time how we did to try to understand the Dobbs decision with an objective mindset, to lead with curiosity and a desire to understand facts, to gain perspective about the current court from our history and examine the current court in this context, conclude with how the citizen fits in and contributes to this landscape. We hope we've accomplished that for you today, and we're really great that you participate in this presentation. We do have some recommended reading, and I'll just show it here. And you can certainly, we have quite an extensive bibliography, but these are ones that we plucked out that probably most reasonable for folks to dive into. And with that, we wanted to thank you for attending. If you want to send us an email with your remarks, here's our email, acitizensoffering@gmail.com.
Thank you all, and thank you, Laura.
All right, thank you.
Goodbye.
Bye.
Okay, well,
I'm stopping the
9:30.
recording.